Hi, good afternoon, folks. It's now about 12:15 Eastern Standard Time. We'll start the conference in about 15 minutes. I see there's a couple of people already online. If anyone has a question, please press *5 on your phone. I'll try to answer a few questions before we get started. Okay. I have one question from area code 314. That seems to be the only one so far. Okay. Area code 314, where are you calling from?
I'm calling from Dallas, Texas.
Yes, sir. How can I help you today?
Actually, I'm working as a consultant since 2024.
Okay.
So I recently got a job. I started here in the 19th of June, but I wanted to continue my first job and second job as as one is part-time and second one is full-time.
Sure.
Meanwhile, I have a little conflict, like 3 weeks of 2 jobs as a 40 hours. I got pay. So will it going to be any effect for my future H-1 visa or something like that?
Okay. So when you work for 2 employers on an H-1B which has been approved as a regular H-1B.
No. No, I'm not in H-1B. I'm sorry for confusion. I'm right now in OPT. So I can do the...
Are you on first year OPT or STEM OPT?
Second.
STEM OPT.
STEM OPT.
Did you file a 983 from the second employer also?
Yes, I did.
Okay. So your DSO was updated that you are going to be joining a second employer, correct?
Yes.
Okay. Double check with your DSO. First of all, there is no law that you cannot have 2 full-time jobs on STEM OPT. If you can do them, by all means. You've got to have minimum 20 hours for each job, but there is no upper limit. Got it?
Okay, right.
That's the first thing.
I was working with the first one and second one.
Right. So that is not a problem. Just double check with the DSO that there is a time period during which you were working for both. And so if they need to do any reporting on that, which I don't think they should have to, just double check with them so that you are in the clear. I don't see it as a major issue. Okay?
Okay, right. Yeah, it's for just 3 weeks, sir.
Well, it doesn't matter. It doesn't matter. Doesn't matter how many weeks. Just make sure that you are absolutely secure from the compliance perspective. Okay?
Okay, right.
Yeah,
meanwhile, I have follow-up questions, sir. I got H-1B picked, which is in a consulate process. So all these things won't affect my consulate process, right?
No.
Okay, right.
All right. Very good.
Yeah, that's what I do have a big deal. Thank you very much for
You're
taking
welcome,
my
sir.
question before the call starts.
You're welcome. Best of luck. There's a question from area code 571. I guess that's my neighborhood, Virginia, right? 571?
Yeah, Rajiv.
Hanji, how can I help you, sir?
I was on L2 visa, and my spouse has lost her job.
Okay.
Before her last working day, for my spouse and for myself, we have applied change of status from L1 to B2 before the loss of job.
Okay.
We didn't take the grace period. And she also has got her H-1B picked in this lottery.
Okay.
So before her last working day, for both of us, we have applied change of status from L1 and L2 to H1 and H4.
Okay.
The change of status application for H1 and H4 was submitted through mail. So her H1 has got approved.
Okay.
My H4 application was first received in a center. I got a receipt number.
Okay.
And then I got another receipt number. 2 receipt numbers I got for the same H4 application.
Are you sure one was not for the EAD and the other one for the H4?
No. It's not for the. She doesn't qualify for EAD. It's only for H4.
Okay, got it. Then?
So I got a 2 receipt number. I'm not sure why I got 2. Maybe it was transferred to another center or something because I got a new one.
No, you should not get a new receipt number for that. What you should do is just contact USCIS customer service and let them know. They should be able to explain to you what's going on. Okay.
So my question was like, on my first application, it was mentioned as it was rejected due to insufficient fund. The second one is still mentioned as pending.
Okay. What do you want me to say, sir? I'm not clear about your question.
So the first receipt number was showing status as it has been rejected because the check doesn't have a.
Right. No, I got that. You don't need to repeat yourself. I just want to know what do you want me to comment on.
I got the 2 receipt number. I'm not sure which one to follow. And,
okay. I just gave you the answer. I just told you the practical answer. Okay. Contact the USCIS customer service. Tell them I have these 2 receipt numbers. Chances are that the first one was receipted, but then they could not clear the check, so they bounced that. And then you file the second one. I think it's the later receipt which is the effective one. That's my guess. Okay?
Okay.
Best of luck.
Thank you.
You're welcome. I think there's a call from, I think it's Boston, right? 617? Area code 617?
Yes, that's Boston.
Yes. How can I help you?
So I see that you have a similar question on the forum too. Mm-hmm. But, my H-4 EAD has been pending similarly for a long time. Mm-hmm. So I would think I could file a writ of mandamus. Would that be helpful? Because, I have a job that would not stay if I don't get my H-4 EAD soon.
There's definitely no harm in talking with the litigator, but I would recommend also a less drastic option in the meantime. If you have a job issue and the EAD has been delayed beyond normal processing time, you can certainly request the government to expedite the case, okay? Because expedite is available if there is considerable financial loss to the employer, actually also to the employee, but they hardly ever expedite for employees. But they will expedite if the employer gives you a letter that they really want you back. And this becomes even more effective if the employer is a nonprofit or is engaged in some effort which is very important for the country.
The problem is it's a new job that has been offered to me. And okay. After a long time, I've been struggling to get a full-time job. This is a new job that will start in August.
Okay.
So I don't know if they would be willing to give me any such letter. It's a university. I mean, it's a community college. But I'm not sure
they might
be willing to.
They might be willing to. Because are you supposed to teach in the community college?
Yes, I'm going to be the full-time teacher, yes.
So then that's a very important reason because they have a session starting and they want a teacher, they want your EAD. I think that's a very good reason to at least request the expedite. Okay?
So you're suggesting that I get a letter from the community college and try to expedite. Is it through the USCIS I have to do it?
I think you should get a lawyer because they should help you review the letter and if necessary, help you also expedite.
Okay.
Best of luck.
All right. Thank you.
You're welcome. All right, folks. We have about 8 more minutes. Anybody has a question they have not posted, press *5 on your phone. Okay. Area code 774. 774, where are you calling from?
Yeah, can you hear me?
I can.
Yeah. It's Massachusetts.
Yes, ma'am.
I just have in general question, nothing related to H1 or OPT. I am on H1. Mm-hmm. So, sir, even in future, if I get I-140 from my employer, which I'm sure I'll be taking that route, it's like, because for Indians, the wait time is too large for physical copy of GC. I have to properly maintain my H1 status, right? Each and every day, even if I have I-140 in hand, like not in hand, but even after that stage, it's like until I wait for a physical copy of a card, just maintain the H1 status in a correct compliance manner, right?
No, I'm not sure I understand your question. Let me just make sure that I do understand before I answer it. What you're saying is, once I'm an Indian, I am backed up in my green card for 10 years, let's say, right? That's one part of your story. If I get the I-140 approved, does that do away with the need to maintain an H-1B? The answer is no, because until you file the I-485, which is going to be 10, 12 years down the line, you have to maintain status. Okay?
H1 status until I-485 is filed, like
yeah.
change of status.
Adjustment of status, yes. Okay?
Okay. So if once that I-145 stage I reach, suppose, then that employer dependency gradually goes down, or still it's like until a physical copy of card arrives, you are tied to your employer and
no.
It's like employer-employer relationship.
Okay, got it. Once the I-140 is approved and the 485 has been pending 180 days, you can actually change employers and take a same or similar job with any employer. Okay?
Sounds good. Yeah, it answers some of my part. Yeah. Down the road, it was just for my knowledge. Yeah. Thank you.
Of course. You're welcome. Best of luck. Okay. Area code 602. Where are you calling from?
Hello, Rajiv ji. This is Pratik. The area code is from Arizona. I live in Seattle right now. And my question is, so currently I am on F1 visa and STEM OPT valid till next year, July 7.
Okay.
And I currently work with Amazon and my H1 got picked, but and the current status still shows pending, review pending. And it was filed on May 6th. And the problem is, I'm about to be laid off, so they have given me 5 days to decide until this coming Monday. So my question is, what would happen if I get terminated before I get the H-1B approval?
Okay. So this is a frequently asked question. I think this presents a number of problematic issues which are not settled by the government so far. I can tell you what I guess the results are and what the best options are, but I cannot tell you that I can point to a particular policy and say this is where the government has said that. So they are all left up in the air. Let's begin with somebody gets laid off before October 1st, having been selected for the lottery, and the H-1B is either pending or even approved. So they get laid off before October 1st. Is your H-1B, by the way, approved already or is still pending?
It is still pending, but I'm trying to buy the time so that I can file for premium processing and at least get the approval.
Okay. So one thing which is quite clear, which requires no great policy interpretation. If the H-1B is not approved, you get nothing. You have no lottery. But here's what you should do. If H-1B is not approved, you should contact your DSO and ask them to reinstate your service. Because if you have time left on your OPT or STEM OPT, that time can be reclaimed. Okay? So you contact the DSO, ask them to reinstate the service, which reinstates your OPT or STEM OPT. However, one of the problems with this procedure is the DSO will not reinstate your service until they see official notification from the USCIS that the case has been revoked. Okay? And the problem is it can take multiple weeks for the USCIS to act upon a revocation request because I don't think they consider this to be urgent. Okay? So far we've discussed two situations. One, if your H-1B does not get approved you get nothing. If it is pending and it gets revoked, you can request reinstatement, but it can take time. And I think the way the government would interpret this situation is that the time you are waiting for your service to be reinstated could be considered to be unemployment time. I'm not sure how that would play out, why that would be like that. More aggressive interpretation would be until October 1st, I'm on cap-gap. Until the case is actually revoked, if it's still pending, I can work on cap-gap. And the answer is yes, that's true. Okay, so there's a lot of confusion in this area. Things that are clear: H-1B doesn't get revoked, you get nothing. H-1B gets revoked, gets revoked early enough, you can reinstate your STEM or regular OPT. All right, now, what if my H-1B is approved, but it is revoked before October 1st? I believe the argument would be that you get nothing because your H-1B was revoked before the lottery began or the lottery time began. Okay. What if my H-1B is not revoked until after October 1st, on or after October 1st, but I have never joined the employer? I don't know the answer to that question because there is no clarity in the policy by this government or the previous administrations either, to be fair. Okay. So we don't know really what happens, but I can tell you this from my practical experience. We have actually been able to transfer H-1Bs even before October 1st, as long as they were not revoked. In addition, I believe you should be able to transfer your H-1B after October 1st. I believe, this is my belief, my interpretation. My interpretation is that if the H-1B is approved but not revoked and you don't have a job on October 1st, I would say you get 60-day grace period, just like everybody else. Okay. And I'll summarize all of this because there's a lot of information. So if your H-1B is not revoked, you might be able to transfer the H-1B. Better scenario is you at least get one paycheck or two paychecks from the company that you are working for who got your H-1B approved. Then if you get laid off or you resign, you've got 60-day grace period. You can 100% transfer your H-1B. No question. What if I work only one day? Well, it's still better than not working at all. So let's examine the order or the ladder of safety. Safest, I actually get my H-1B approved. I am working for that employer for at least a couple of pay periods. Second, at least I'm working for them for one day, let's say on October 1st. Third, I did not work for that employer, but my H-1B is getting transferred because I'm not getting revoked before October 1st. Anything below that is risky and we don't know what will happen. Does that make sense? Are you good?
Yep.
Yeah. So I'm going to ask Monica to or Deepa to extract this part because this is very commonly asked. And if anybody has a question on this, they can just log in. Oh, you know what? I'm going to have to lock the conference. We have enough people in the conference already. Give me 1 second. Let me just lock the conference.
The conference is now locked.
Okay, folks. So we just discussed that. Pratikji, can I go on? Are you good?
Yes.
All right.
Thank you so much.
All the best, Ji. Okay. So, folks, this call is already being recorded. Most of you already know what the process is. So what we are going to do is I'm going to go to the posted questions first. Within posted questions, I have marked some questions as frequently asked. I'll answer each question. After each question, I'll request anybody has a follow-up question to please ask it. I will answer the follow-up question because that way we can keep all the subjects tightly together. Remember one thing, only follow-up questions. I'm hoping I'll be able to finish all this in 30 minutes. Then we'll have at least 30 minutes to answer new questions. But my aim is, even if it takes a little bit more than 30 minutes, my aim is to try to answer everyone's question who's here. Okay, so be patient. Please don't ask me anything that's not a follow-up question. Let's begin with the frequently asked questions first. One was, this is a question that has been posted, question number 7. What are the risks of job seeking while on F2 or B1, B2 status post H1B layoff? So in my opinion, there should be no risk. I should not be forbidden from looking for a job. I'm forbidden from doing the job. If it is my intention, and this is my interpretation, okay, government may not agree with me. My interpretation is, if it is my intention to look for a job but not begin a job until I get properly authorized, there is nothing, I'm not violating any law. How is that a violation of the law? And this is especially true for B visa cases, B2 cases, where personally when I file, I tell them I'm going to look for a job. Now, are they going to deny the B visa? So far they have not, or B status. So far they have not. But there are people who are concerned about it, including some of my fellow lawyers. So what am I doing? Bottom line, when I get a request for a B1, B2 application help, we'll file the B1, B2 and we'll be truthful. We don't lie to the government that we are doing it for rest and recreation. That's nonsense. I'm going to look for a job. I'll be upfront and tell them I'm going to look for a job. Okay. I had a couple of, one lawyer and a couple of individuals from the community tell me that they were having a problem when they tried to convert back to H1 from B1, B2. Government sent an RFE saying, you're not supposed to look for a job on B1, B2. And I told them that's utter nonsense. Fight it out. I don't know exactly what happened because this is still relatively new. Personally, I think they'll win the case. But even when the policy was archived by the Trump administration a few weeks back, we were still getting B1, B2 approvals. So I'm assuming, because we clearly tell the government we are going to look for a job, I'm assuming we'll keep getting approvals until I hear differently. And if you have a case that is different, by all means, let me know on my LinkedIn account. Most of you are already connected with me. If not, feel free to connect. So we'll take it from there. I think that you will get an H-1B approval. Worst case scenario, government can say, no, you have violated your F2 or B1, B2 status by looking for a job. We'll approve the H-1B, but you have to go outside and get a visa stamp and come back. And if you already have an H-1B visa stamp, you can use that. Just get a cup of coffee in Canada or Mexico and come right back. Not the end of the world. Okay. *5. If anyone has a follow-up question on this, press *5. One follow-up question from area code 857. 857, where are you calling from? 857?
Yes, I'm calling from the Boston area.
Okay. Tell me, what's your follow-up question?
Yes, so the follow-up question for this is, say if we are filing for B1, B2 to H1B, right? Like change of status, you mentioned about RFE.
Right.
Is there a need to, say, attach a letter or something where it states that, we have not worked on the B1, B2, and we are willing to work once the change of status is approved?
No.
Something like that,
No.
I would send out a...
No. I would not proactively provide an explanation. I would file my H-1B and I would wait. If the government wants to make an issue of it, then I'll provide an explanation. Not before. Okay?
Okay, and the B1, B2 approval, if it is provided, there is a letter and it says that the intent for B1, B2 was job search. That needs to be attached.
I wouldn't do any of that. I would just simply file B2H conversion. Okay?
Okay.
All right. Best of luck.
Thank you.
You're welcome. All right. Let's go on to the next frequently asked question. I thought there were one or two others. Oh, maybe not. Oh, there is one. Here is one. The question is F1 change of status risks of future denials, job search and visa stamping with multiple status changes. So I think here the fear was, if I have done too many status changes, is that a problem? But let me double check. I came on F2, converted to H4. I don't have a visa on my passport, of course, because you converted within the United States. And I'm going to change to F1. So F2 to H4 to F1. Is this a problem if I want to convert back to H4? No. I don't think there's a limit. I mean, I know there's no limit to how many times you can change status. And these all appear to be very relevant changes. You're not doing it for the fun of it. Each time you file one of these applications, you're paying hundreds of dollars. So the answer is, I don't think it's a problem. And I don't think in visa stamping, this is a major issue. Star 5. If you have a follow-up question, please press star 5. Okay, let me go on to the other questions that are not frequently asked questions. Question number 2. H-4 EAD renewal delay, C26 540-day extension concern. So there's 12 months of processing time delay in Nebraska Service Center. I'm from India. I've filed several H-4 EADs since 2016. How can I get my application decided immediately, or let's say in 15 days? You can try expediting if you have a good reason. I think the government gives you 6 reasons you can get expedites. The only time I have been able to get expedites rather easily, where there was a public interest angle. So somebody had an EAD and she was working for an electrical cooperative organization which provided rural electrification. So when I asked for it, they actually gave me an expedite over the telephone right away. Okay. Why does a 765 take over 12 months? No idea. Is there a way like India's RTI to access data on how many I-756 were received and processed each month? They are not going to give you current data. I don't think there's a process for it. But they might be able to, there is past data available. Number 4, what happens if USCIS fails to adjudicate within the 540-day extension window? Well, first of all, I am a little concerned if you understand this clearly. Because for H4, I'm speaking from memory, for H4, you don't automatically have 540 days grace period to continue working. You have 540 days or the time remaining on your I-94, whichever is lesser. Okay? So if your I-94 is expiring tomorrow, you have filed an EAD extension, you can't continue working after tomorrow because your I-94 is expiring tomorrow. Okay? That's not how it works. Press star 5. If you have a follow-up question, press star 5. Okay. Area code 208. 208, where are you calling from?
Hi, I'm calling from Chicago.
Yes, sir.
So this question is posted by me.
Okay.
I have few questions, and based on the previous answer that you gave as well to some other lady as well on this H-4 EAD.
Okay.
I think your reference, what I am getting at is that you feel that writ of mandamus or something else is a more extremist step.
Yeah, let me lay out what the actual picture is. Okay. Most lawyers I know are going to charge you at least $10,000 for a mandamus. Okay. So what happens? Let's say it takes them 7-8 days to prepare a mandamus. Maybe earlier, maybe 2 days or 3 days. They file it. They will get summons issued, which have to be delivered to the government, and government will then have 60 days to respond. Okay. If the U.S. Attorney's Office is reasonable, they might be able to look at the case, and your lawyers can reach out to them and say, look, you want to settle this case, just get the EAD approved. That can happen. If that happens, within a week, 10 days, you've got your EAD approval. So in 2-3 weeks, you've got your EAD approval. That's in a perfect world. But what if the U.S. Attorney's Office has been told, don't settle any immigration cases, fight them? Although that's not true. Cases are being settled even now. If they choose not to settle, you are stuck, because you could be stuck for weeks and weeks and weeks in trying to get this thing processed. And if they end up answering the complaint and they want to take it to trial, you are looking at a year plus of time. If you go summary judgment, maybe 6 months time. I'm not sure it's worth all that, but again, I could be wrong. I'm just telling you what I have seen in my personal experience. But remember, I told you there's no harm in asking a litigator what they think, because every area has different flavors. Some U.S. attorney's office are very easygoing. They are ready to settle cases and move them along. Some are not. That is why I made that recommendation. The money and the time involved.
I have two more quick questions on this. You told about the amount of money and the time spent with the attorney who is going to file it. Do you think I can file myself? There is something called as pro se. In which
people are filing pro se, and I know that there is at least one firm who's helping people file pro se. Can you do it pro se? Yeah, I think you can. I'm not sure you'll still save any time. Money you might save. And I'm not even sure that government is as inclined to settle these cases. I don't have any experience with pro se. So you can ask around if other pro se filers have had good results. Why not? I mean, it's just English. If somebody can explain to you what the rules are and give you sample pleadings, you should be able to do it.
So I can also take this bilateral approach of doing expedite request as well as the pro se filing of writ of mandamus.
One problem. Once the complaint is served, the file tends to get relocated to the U.S. Attorney's Office. They will not process the file, I think.
Okay.
So you may want to get the paperwork ready, get the complaint filed, but maybe serve the government once the expedite has been refused.
Okay. I already have done the work almost. It is almost 99% complete from my side. But
Okay.
I have been I know you from before as well, and every time when I come to you, I feel you give the best advice.
Okay.
And I feel like on the expedite request, the problem that I was facing when I read through all the forums and details is that even the CIS is saying there has to be an expedite request for very specific things, either for non-profit organization, where it has to be some cultural or something else, where we are not working for a non-profit organization where the job loss is.
Well, hold on. I just got an expedite, not very recently, but about a year back. I got an expedite for an accountant who was working for a government contracting company who was performing some contracts for the U.S. Navy. So we told the USCIS that, look, this guy is extremely important for these contracts. Government contracting is a very specialized area. Okay. So for somebody to do cost plus accounting on government contracts, we need somebody who knows what the rules are. And that was expedited very, very quickly, within a week or 10 days. So it's not that it has to be only a cultural thing, but sometimes it depends upon if there is a public interest angle, it plays better.
Yeah, in my case, it does not really apply. That's why I'm kind of cornered from that perspective. Why? Because I'm doing a part-time job, which is not really full-time and not with a company.
Right.
So I am doing jobs and then making use of H-4 EAD as much as I can, but the job market is not as great as well.
Right.
So
yeah, I mean, you can. Chances of getting an expedite are pretty small. So writ of mandamus, by all means, go ahead. Okay.
And I think the other question was on the 540-day extension. So I understand 540-day extension is the lesser amount of time from which the H-4 EAD, the H-4 status is starting, or when I file for the extension. I think there is something like that.
No. So wait. Government says you have, I'm again speaking from memory, There are so many little provisions, I can't remember them all off the top of my head. The way this works is, you have 540 days from the date your EAD expires, 540 days or I-94 duration, whichever is less. So if your I-94 expires the same day as your EAD, you have no grace period.
Yes, I understand that. So my H-4 EAD expired last April.
Okay.
And the new H-4 status has already been extended. So that will be until 2027.
Okay.
So the lesser of this time, 540 days, happens to be somewhere in August or
Okay.
September.
Listen, I have to go on with the call. Can you wrap up? Anything else I can help you with? One last question?
No, just one last question would be is for the expedited request. You said there is a template that we have to follow, or do we just contact USCIS and then we
they have given you a procedure now, and I think it involves calling the helpline. So you can go ahead and just Google it, USCIS expedite process. Okay, they'll give you, okay, these are the 6 criteria, and this is what we want you to do to expedite the case. Okay. All the best.
Sounds good. Thank you, Rajiv.
You're welcome.
Okay, thank you.
Okay, so we talked about this. Next question, number 3. AC-21 eligibility after EB-2 interfile and pending 485J. Can I port to EB-3? Company A filed my EB-3 I-140 and 485 concurrently. Okay. Company A got EB-2 I-140 approval using the same perm and interfiled. Got it. I moved to a new job with company B. 485J filed with interfiling to EB-2 is not yet approved. This is not an easy question to answer. So let's see. My first case, which was EB-3, that was filed back in 2020. In 23, I moved to a new job and I had filed a 485J. So I think what is going to happen is your 485J for EB-2 is the one that will count, even though it has not been approved. I think that's the one that would count. And the reason we don't have to worry about the AC-21 180-day count is because this is back in 2022. So you're definitely over 180 days. So the way the government counted these days was, and they actually published a policy on this. They said, let's say you have already covered 180 days, but then you file an interfile request. We'll start counting 180 days again from that date. So even if we counted that date, you are more than over that date. So it appears to be very clear that you are, at least to me, you are under EB-2 portability. Okay. Now, if you are able to get on the phone and get the government to rescind the conversion from EB-2 to EB-3, no, you went from EB-3 to EB-2, and say, look, we want to rescind that. I think the chances are small, but you can try to do that, and then you can stay on EB-3. So you can say my AC-21 portability is on EB-3. Can I now file AC-21 request with company B under EB-3? And my problem with that is because you have an EB-2 request pending, and I'm not sure you can withdraw that request. I think it may already be too late for that. That's my answer. Press *5 if you have a follow-up question. But it doesn't hurt to check with them, okay? The only thing I'm always concerned about is that you don't get very reliable information from the frontline staff. Okay, let's see. This is a New Jersey question. New Jersey, how can I help you?
Hey Rajiv, thanks for taking my question. So you are saying that I cannot directly go back again to EB-3 with the new company, right?
I see. The problem is this. Here is the problem. Why can you take your green card over to a new company? You can take your green card over to a new company because something has been pending for 180 days. That something, in this case, appears to be your EB-2, not your EB-3. If you were with the old company I might have said, well, you're with the old company. I can request a rescission of the E2 request because they have not yet granted. I'd be very reluctant to do at this point because there is just really no policy on this issue. Okay. So I think EB-3 fallback is difficult with another company. Okay.
So I can go with my old company again, EB-3 directly, new interfile to EB-3.
I wouldn't interfile. I would just file a 485 for EB-3.
New 485.
I would just file a new 485. Because now I have no risk. I'm with that company. I don't have to worry about the 180-day portability rule.
Okay. No, I'm saying old company.
Exactly. That's why I'm saying, the company that originally processed your EB-3 and your EB-2, if you go back to them, you could directly file a 485. But there's another risk there. Government could come back and say, if this is a permanent job, why did you leave? And why did the company let you leave? We don't think there's a permanent job. The whole green card is denied. So it's not an easy situation. I would personally just stick with my EB-2 and stay where I am.
Oh, okay.
All right.
Okay. And you are not going back to original company and again going back to EB-3 is a risk you are saying. Okay.
I just don't like it because, like I told you, they can say, hey, you are saying green card job is a permanent job. How come you are leaving them then?
Okay.
This is not easy.
Okay.
I mean, somebody else could say, but green card is a future job. Yeah, but you are already working for that company. You see what I'm saying?
Right.
So, if you were my brother, I wouldn't let you take that risk. Let's put it that way.
Okay. Thank you, Rajiv.
Best of luck. Okay, so then we come to Dhananjay Singh. Question number 4. I want defining use to avoid status abandonment, H-4 status and green card EAD. I'm not sure what that means. Let's see. I'm currently on H-4 EAD. Expires in July 27. Employer filed I-485, I-131, I-761 for both of us. So, going through your wife. My green card I-765 was approved as a standalone approval and I should receive the 5-year EAD soon. My question is, if I wanted to keep my H-4 status, I understand I should not be using my green card EAD. That is correct. What does it mean to use green card EAD? Very good question. What it means to use your green card EAD is, you take that EAD and you go to an employer and you tell them, hey, you have my form I-9, please substitute my current EAD with this EAD. That's using it. Okay. So do not use the green card EAD as a work authorization with any employer. What if you're doing business for yourself and you have both EADs in your pocket, H-4 EAD and green card EAD? I don't think anybody can say you are using green card EAD. You can always say I'm using my H-4 EAD, and that would be just as correct, right? It's only when you use it for an I-9, it becomes quote unquote using. Can I travel domestically using green card EAD? Yeah, that is not using EAD. That is merely identification because traveling is not work. Okay. Can I use green card EAD at the DMV? Absolutely. Can I use green card EAD for I-9? That is where the problem is. If you use it for I-9, then you are using it. Okay. Star 5 if you have a follow-up question. Press star 5. Bila Ravi, number 5, question number 5. H-1B termination without onboarding payslips, implications for new employer transfer. I came to the US in March on H-1B, holding a letter that said my job starts from X day. They have marketed my profile, they stopped marketing, and they terminated my H-1B. But there's no official email. They told me they never onboarded me, so I'm not their employee. That's not how it works. That's not how it works. So, if you enter the United States and you are willing to work and you report for work, they have to start paying you right away. Whether they onboard you, whether they find a client for you, that's their problem. The employer has to start paying you as long as your H-1B is active on the date you report and be ready to work. Okay. Now you don't have pay slips. So when you don't have pay slips, getting a change of status or transfer of employers is difficult. What I recommend to people is file a complaint with the Wage and Hour Division of the US Department of Labor saying they didn't pay my salary. Because in order for them to, there is no doubt whether they onboard or not, you are their employee. And their obligation to pay you begins on the date you report as ready and willing, as long as your H-1B was active. In order to terminate your employment, they have to do three things. Number one, they have to tell you from XYZ date you don't have a job. Number two, they have to inform the government, USCIS, to revoke your H-1B. And number three, they have to offer you a one-way ticket back to your home country. If any one of these things is not done, you are entitled to your salary until it is done. File a complaint, take a copy of that complaint, and when you file the H-1B transfer, attach that complaint saying, I was ready, my employer didn't pay me. I would be surprised if you don't get change of status. Best of luck. *5 if you have a follow-up question. Press *5. All right. Okay. Area code 479. 479, where are you calling from?
I'm Ravi, who I posted the comment. So
yes, Raviji.
So one question, I have few questions here. So while coming, myself, I booked the flight ticket. So
even that doesn't matter. Even that doesn't matter. I don't know of any rule that says the employer after approval can say, sit at home for 3 months and then we'll call you when we are ready. If you have arrived in the United States and you have reported for the duty and H-1B is active, they have to pay you. Okay. Next question. Make it really quick. Ask your questions quickly, please. Yeah.
So actually, my brother-in-law is also working there. So what if what is the impact for him in the future if they agree to pay the salary for all these months? So they put the reserved salary of him under them.
That would be illegal. Next question.
Okay, is it necessary to reach out to the lawyer after some time after getting back?
No.
Okay.
No. So if you Google, just Google this, Wage and Hour Division LCA complaint. Write it down. Wage and Hour Division LCA complaint. Wage and Hour Division is a branch of the Department of Labor that investigates these salary issues. They are extremely helpful. And it doesn't cost you a penny to recover your money.
So this is like I have to complain to the New Jersey department? Or
no, this is federal. This is the US Department of Labor.
Okay, perfect.
Yeah.
Okay. Thank you so much.
Best of luck. All right, guys, I'm getting a little slow here in my old age. Let's keep going. H-1B layoff, B-2 denial, and war? What the heck? H-1B layoff and B-2 denial and war. After H-1B layoff, B-2 extension is denied for job search. Is it possible to get stay in the US based on war situation in home country? Well, you should talk with a lawyer who does asylum laws. Okay, this is not really my field, and my answer is I do not know. Check with a asylum lawyer. Is there any other way to stay in the US? No, not that I can think of. If the I-140 is approved, can you stay in the US? Well, it's too late because you already are out of status. If you were not out of status, you were still on H-1B, and there was a reason, you could have asked for compelling circumstances EAD. Okay? *5. If you have a follow-up question, press *5. I think going back is the only option at this point of time. That's the only thing that makes sense to me. Area code 217. 217, where are you calling from?
Sir, I'm calling from California. So one follow-up question I have is, initially also you were saying that we can apply for B2 if we are H-1B laid off. And let's say we want to, we get it approved and then we want to change it from B2 to H1B. The application gets approved, but the but the officer says that you need to step outside of the country and then come back. But let's say I also have a valid visa stamp. Then let's say I do step out of the country. What if they don't let me enter because of anything?
No, there is absolutely no guarantee that you can come back in. But this is the normal procedure, and it has worked for thousands of people before you. Could you be the exception? Yeah, sure. Nobody can guarantee your re-entry. Okay. Next question, please.
So one more question that I had was, like when we are creating a cover letter for the B2 petition, B2 application, do I need to also mention my LinkedIn profile, my email address through which I'll be doing my job search?
No, I unless the I-539 instructions ask for it, there is just follow the I-539 form and instructions. That's all you do. Okay.
Okay.
Best of luck. Next question we already did. That was a frequently asked question. H-1B re-entry risk, visa expiring in 2 months, extension not yet filed. Okay, this happens all the time. My visa is valid for a couple of months. My H-1B is expiring. They have not filed an extension. Just to be safe, I would carry a letter from my employer saying they intend to file when I come back. I just did that for one of our clients. They just had, I think, a few months left on their H-1B, and they were traveling. They had an urgent situation. So I said, you know what, let's just give them a letter that says we intend to file. And for another client, I actually was able to give them Federal Express delivery that their extension had already been filed, because you can travel during extension. You can't travel during change of status. Okay. So let's see what the question is. Question is, my first 3 years of H-1B is valid till 25. Employer is currently prioritizing filing extension, whose visas are expiring in a month. Family emergency. Is it risky to travel? No, I think it's okay. Should I postpone my travel? That's up to you. You have to discuss this with your lawyers. But it's clear that you can travel during extension. It's also clear that if you have an extension pending, and you have time left on your visa stamp, they should let you back in. Okay. My company's contract with current client is till November 25, most likely will be extended. Considering the visa is expiring in 2 months, what should I answer? Well, it's not like you have a choice. If you are asked a question, you have to answer it truthfully. It's not that you can take option A, B, C, D, and E. You have only one option. A, tell the truth. Whatever happens, happens. If you get caught in a lie, it's a permanent bar from entering the US. You can never come back. Not even if you get married to a US citizen. Getting waivers is very difficult on those things. Okay? *5, if you have a follow-up question. *5. Okay. Next question, which is number 9. I think we just have a couple of more questions. What are my H-1B options after layoff to maintain status and travel for November wedding? Got laid off. I understand I have a 60-day grace period. Sure. We are getting married in November in India. Everything has been arranged. It's very important for us that I maintain my legal status in the US so we can stay together. There is no way your return can be guaranteed. Okay. Now, if your wife, who will be your wife, if she's on H1 or F1, you can certainly try to come back on F2 or H4. H4 is pretty easy to get. Okay. But if you say, I get a B1, B2, can I come back? There's no guarantee that you'll be able to. So the only reasonably safe option is a derivative option, where you come back with a derivative of your spouse. Okay. B1, B2 will get you your temporary stay in the United States, because while the application is pending, you can stay. Even if it is eventually denied, all that period that you stayed is not illegal. That's legal. *5, if you have a follow-up question, press *5. Excellent. Area code 860. Where are you calling from, 860?
Hi, Rajiv ji. I'm calling from Seattle.
So I just had a follow-up question to this. I wanted to know if I can, so currently I'm on H-1B, and if I can switch back to H-1B when I find a job on H-4. If yes, would it be a problem if I do not have a H-1B stamp yet? So would that be like an abandonment of my H-1B status?
Well, you did receive a change of status, right, to H-1B?
Yes.
And you did work for that employer, right?
Yes.
So the answer to first question is yes, and the answer to second question is no. First question was, can I change? Sure. Is that going to be a problem? No. No issue at all. All right.
All right. Thank you.
All the best. Let's go on to the next question. I believe this is there's another one from area code 774. 774, where are you calling from?
Massachusetts again, Boston area. So just a question. I have H1 from last year, October, but I don't have any plans to go for stamping, and my F1 stamp has already expired in July 2024.
All right.
Because of change of status, it should be okay, right? I have no plans to travel for next 5-6 years.
Yes.
I'm okay, right?
Yes.
Thank you.
Absolutely no problem. Okay. As long as you have your I-94, which is valid, you're all set. All right.
Sounds good. Yep.
All right. Best of luck, ma'am. Okay. Next question. Okay, that one we covered. This one is N400. Impact of employment gap after EB-1B I-485 approval. So EB-1B, okay. I am seeking your advice, N400, 2017, I-140 485 filed, 2019, I-140 approved, Q1 2020, AOS interview completed. I had been employed with the employer for several years. Q2 of 2020, I got laid off. Now here is the interesting part. Your intention during 485 counts the most at two stages. Number one, when you filed the I-485, you had the intention to stay with the employer. Number two, when the I-485 was approved, you had the intention to stay with the employer. If for no fault of your own you get laid off, I don't see any problem. I-485 approved and green card issued post layoff. I think you'll be okay. Can the government still try to make a mess of it? Sure they can. Okay. So because Q1 2021 you started looking for a similar job, of course. The point is, in the 2020-2021 time zone, there was no requirement that we filed anything like a supplement J. So there was no procedure when things happened in a quick succession. I got laid off, then my green card got approved. Too quickly. Everything happened too quickly. There's nothing you can do about it. Okay. So personally, I think you're going to be fine. And always remember to tell the truth. Don't play any games with the government. And if you are a little bit hesitant, just take a lawyer with you to the interview. Okay. *5. If you have a follow-up question, press *5, please. Okay. This I think is the... Hold on. Did I miss some questions? All right. Oh yeah, I did miss a frequently asked question. Okay, I'll go to that. Let's do this one first. We just finished this one. Then we have, I think, two more questions. One is H-1B extension beyond 6 years with approved EB-2 NIW I-140. I have an I-140 from approved employer, who sponsored the EB-2 NIW. I'm aware that it can get tricky if I'm with a different employer. My question is regarding renewal of H-1B. If I change employer and move to a different title, would my I-140 be useful in renewing H-1B beyond 6 years? Yes. Until that I-140 is revoked, you can still use it to get H-1B extensions. Press *5. If you have a follow-up question, press *5. Texas, area code 682. Texas. How can I help you? Go ahead, please.
Hello, Rajiv ji. So this is like employer-sponsored EB-2 NIW. So it would be tied to the endeavor of the work that I'm doing at my current employer. My question was like, if I change a different employer, the endeavor might be little different, or it would be different than what was mentioned in the endeavor, and would still the I-140 be useful for renewal of H-1B?
And the answer is yes. Until that I-1, because we are not looking at the merits of the green card. We are just looking for an I-140 approval. If an I-140 is approved, I can get my extension.
Okay, thank you.
Okay. By the way, has the I-140 been approved for 180 days?
No. Yeah, I know they can revoke it before that,
Yes.
but I'm about to reach the 180-day mark.
Okay. So once it has been pending or it stayed approved for 180 days, employer's revocation does not impact. Okay?
Okay.
Best of luck. All right. This, I think, this was Patra's question, which I don't know what happened. I kind of got, it got missed. This is H-4 extension I-539 abandoned by travel, refiling strategy after re-entry. Okay. I'm on H-4. Current visa valid till August 25. Husband's H-1B extension approved. And we filed my H-4 extension, receipt notice April 2nd, 25. Family emergency, I went to India April 29th, re-entered on June. I got a new I-94. Will my pending H-4 extension be considered abandoned? The answer is no. It's the traditional rule, and again, I've never been able to find a particular source for this rule, that you can travel during extension, you can't travel during change of status. Change of status, we know you can't. But that you can travel during extension, I don't know where that comes from. But that has always been the case. Should I apply for a new H-4 extension? No. Do I need to file a new H-4 extension before the expiry? No. Is there any additional action? You can call USCIS customer service and try to get to a higher level tier 2 officer, and they can confirm what I just told you. Just give you some additional peace of mind. Star 5. If you have a follow-up question, press star 5. Yeah, this was a frequently asked question. For some reason, I phased that out. Okay, last question. Unemployment benefits, health insurance, and their impact on B2 extension and green card. I was on H-1B, got laid off, converted to B2. Does applying for state unemployment benefits, such as health insurance? Okay, so health insurance is not unemployment benefit as far as I know. Unemployment benefit comes from unemployment insurance, which is something the employer pays for. So that's just like getting reimbursed for somebody banging your car. Okay. As long as the rules of the state allow you, while you are not on work authorization status, to draw unemployment, it's perfectly legal to do so. Health insurance, I don't think is a part of that. Okay. If you are only taking unemployment, that should not be an issue for anything. Press star 5. If you have a follow-up question, press star 5. All right, friends, let's start with any question anyone has. Press star 5. Any question at all. So far, only 2 questions. Oh, this one is easy. 3 questions. Oh, this one is real easy. Good. 4 questions. Still easy. All right. 4 questions. Very easy. 917. Oh, 6 questions. I spoke too soon. 6 questions. Let's start with 917. 917, where are you calling from?
Hi, Rajiv. I'm calling from Chicago.
Yes, sir.
So I have a 2-part question. I'll be quick.
You are not one of our clients, are you?
Yes.
I know. I remember your name. So you could have just emailed. You could have just emailed me. You didn't have to come to a community call for this. But go ahead, please.
That's fine. So first question is, what happens if I travel to India and my NIW is under processing while at the same time my H1 transfer to company B is also under processing. Am I okay with that?
Yeah.
Given
absolutely.
like these two are different.
No problem.
Kind of.
No problem. Go for it.
Okay.
No problem.
Okay, and the other question was like.
And by the way,
like in general,
by the way, because I know I drafted your NIW, I don't remember the case, but I can tell you this, that I always keep room for change of jobs.
Always keep room for what? Sorry?
Change of jobs, so that NIW doesn't fail if you change jobs, as long as you stay in the field.
Oh, right. That was my other question. Okay, yeah. Okay, yeah, that's all I got.
But
so
you know what?
NIW,
If you want us to double check, you can just send me an email or send an email to your case manager or Kunal, whoever worked with you. Just send an email so we can talk, and I can just make sure you understand what the framework is. You know, what kind of job can you do and still not disturb your NIW. All right?
Got it. Okay, thank you so much.
You're welcome. Okay, yeah, I some of the people I recognize just from the name. Area code 857. Where are you calling from? 857? 857.
Yeah. Hi, Rajiv.
Hello? Yes.
Hello.
Yeah, where are you calling from?
So I had a question. Yeah, I'm calling from the Boston area.
Boston area.
So
okay.
I had a question related to B2 extension.
Okay.
So given currently that there are some situations about like moving from H1B to B2 getting denied and stuff.
Mm-hmm.
So what should be the intent for B2 extension if I'm to apply for it?
See, I tell the truth. I say, look, I'm in between jobs. I'm going to look for a job, but of course I'm not going to work illegally.
Okay.
I tell the truth.
Got it. And okay. And say if I'm to like, because we'd be applying for a change of status in that case and not just employer transfer. I mean, initially, like telling that information to the employer, would that be a good option, or do we need to wait till the legal, proceedings begin?
Your question is what to tell the future employer? Is that your question?
Yeah, the future employer in that case, because it would be like change of status and employer transfer of H1B. Right?
Yeah, but remember one thing, if your B2 is still pending when they apply for an H1 and the H1 is approved, it will be approved with counselor processing option, which is fine. And personally, I always tell the whole truth. I don't beat around the bush. I tell the employer, this is my situation. Okay. So, but this is a personal decision.
I mean, we'll have to apply for change of status also, right? Like if,
well, you see, when a case is
when
a case is pending, like a B is pending, 60-day grace period is over, you can't change status because you have no status. You have authorized period of stay. Status comes when B2 is actually approved.
Okay.
But you can try. Government can still give you a change of status if they want to. So certainly try by all means, but don't depend on it. Okay. You may have to step outside and come back in with a visa. All right.
Okay. Thank you.
Best of luck, Ji. Okay. After this question, I have 3 more. So just thank you for your patience. Area code 945. Where are you calling from?
Hi, Rajiv ji. I'm calling from Dallas, Texas.
Yes, sir.
Yeah, so I already, asked you this question on last week call, and after that I had a conversation with 4 other immigration attorneys as well, and 2 has, answered this, same way that you did, and 2 answered it in a different way. Like, so my question basically, so I'm confused now because all 4 are like renowned immigration attorneys, like they're not like new. So that's why I've come back again to, confirm maybe I would have, asked the question incorrectly.
Okay.
So the question was, I'm currently on STEM OPT. my employer is willing to file for my like H-1B is filed, willing to apply for my green card as well through EB-2, right?
Okay.
And then I have EB-3 DOL pending as well through EB, like green card through EB-3.
Okay.
So when I'll receive my green EAD through EB-3, can I work for that EB-3 employer and also for EB-2 employer together? So two attorneys said no, because once you start working for EB-3 employer with that EAD, you will lose your H-1B status. Then you cannot work for that employer.
That is absolute nonsense. Absolute nonsense. You can quote me on that. Okay? Because the EAD that comes with the 485 filing is considered to be open market EAD. Okay, what does that mean? Okay. That means if you want to drive a cab at night, you can. Okay. And if you want to carry on your own business, you can. As long as you have the intention to continue working with the sponsoring employer full time and take their job when the green card comes, you can do whatever else you want on the side. So that answers that question.
How long do I need to work for that?
Like for that, that is a very, very, very long question. You can go to our frequently asked questions, read up on it. There are so many things. I can't discuss them in 5 minutes. It'll take time. Okay. But as far as
the confusion is, I can work for both employers together, right?
Absolutely. As long as.
And do I need to inform my EB to employer?
No, that is an issue of state law and contract law and For example, in Virginia, there is a implied duty of loyalty. You cannot work behind my back with another employer. But that's not through immigration law. That's a problem with the state law. So the question you are asking me has nothing to do with immigration law. Are you required under immigration law to inform them? No.
Yeah, I just wanted to make sure, like, I'm not breaking any immigration.
There is no immigration violation here. All right.
Perfect. Then, yeah, because one employer is completely remote and they are fine with, and they also know about it. They're like, we don't care until and unless you complete our task.
Okay.
So they are completely fine with it. But EB-3 employer is making an issue like that. They are saying like, you have to leave.
You know what? I would be worried that you don't get sued. Just make sure that you've talked to the lawyers who do with this kind of work, employment law. Make sure you're not exposing yourself to litigation. Okay.
Okay, perfect. Thank you so much, Rajiv.
All the best, Ji. Okay, last 3 questions. Area code 629. Where are you calling from? Area code 629.
Hi, this is Narmeen. I called last week too.
Oh, yes. How are you? Yes, of course I remember you.
Good. Yeah, nice. My question is, I think I'll just give a refresh. I was on CPT, I was on OPT. It expired in June. I got laid off. I was on a green card track, but since the layoff, it got canceled.
Okay.
Should I try to do NIW right now, even if I don't have a job?
Narmeen, you don't need a job to file an NIW, but you do need an idea, a project. I give examples of these 2 young ladies. Both of them had developed apps. But the reason both of them were able to get an NIW, one had actually got some universities to sign up for her app. And the second one had received funding from seasoned investors for her app. So remember, they were both really not, they didn't have a job at the moment. But they had projects. So if you have a project in mind in the future and you can show that some progress has been made towards that project, you can file an NIW even now. Only some people are so qualified that there are not too many questions asked about their NIW. Most people need some kind of a project. You don't need a job though. All right.
How about the H-1B self-petition? I've been seeing this one a lot.
Yeah, that's far more complicated, Narmeen, because First of all, you were on H-1B before, right?
No, I never got it.
So you have to go through the lottery first of all. Okay.
I did 5 times.
Even for your own company, you have to go through the lottery. So that is out. All right.
I see. So I guess the only option here is just re-enrolling in school for this
Yes,
case.
that is an option. And also a good option, especially if you pursue a degree that's going to help your career. Okay. A lot of people are going back to school simply because the job market is tight, and this is as good a time to get an education rather than look for a job as any. So yeah, going back to school is definitely an option. As long as you're within the 60-day grace period, they can roll over your service to a new course. Any school can. All right.
All right. Okay.
All the best, Narmeen.
Thanks.
Bye. Yeah, I remember you. I asked you if you speak French. Area code 806. Okay. 806, where are you calling from?
Hi, Rajiv ji. My name is Hemant. I'm calling from Lubbock, Texas.
Haan ji, Hemant ji.
I have a doubt regarding the birthright citizenship. Is that okay to ask?
Of course. Go ahead.
So, to give you the context, my baby is due in August, and given the uncertainties going around, and even today, a judge from New Hampshire has blocked the Trump's order. So, what do you think about the birthright citizenship? And if at all, if it is passed in Texas, would the baby be stateless, or what do you think about it?
Okay, so this is what I think. Okay. I'm glad you asked this question. You know what? Can you stay on just for a couple of seconds? Let me finish the next caller, and then we can talk about your situation, because I want to spend a few minutes on that. So I'm gonna ask the next caller to log in your 806 area code. I'll come and get you. Hold on one second. Let's see. Oh, there are 2 more people before you. Okay. Area code 217, go ahead, please. How can I help you? Where are you calling from?
Sir, I'm calling from California. I had only this one question. It was related to the unemployment benefits thing that we were discussing previously. So I read about the unemployment benefits, especially in California. Is it possible that when you are unemployed, we can also get some minimum amount of wage per month by the government?
Okay,
is it
so that is,
or is it not?
Yeah, that is a compensation, unemployment insurance. Okay, so that's not considered to be a handout. Your employer has paid for that. So the only concern I have is, from state to state, there might be a requirement that you must have authorized work status to receive that payment. Just check on that. Other than that, under immigration law, receiving unemployment compensation is not a violation of any statute that I know of. Okay? Just worry about the state law.
Got it.
All right? Best of luck.
Oh, okay. Got it. Thank you.
You're welcome. Okay, 774. After that, I'll go back to Birthright. 774. Aren't you Boston? I think I've talked to you like 3 times already. Right?
Yeah, same. Same. Sir, on H1 also, if I'm more interested in education and I'm thinking to get some degree from Harvard, it's allowed, right, to keep on studying and working even if I'm on H1 status?
Sure. People do it all the time.
Yep, sounds good.
All right.
And sir, if you don't mind, even I want to listen to that Birthright thing.
Of course.
Can I be in the...
Yeah, of course. I'm not.
Please.
I'm not disconnecting anyone. So let me just go to area code 806. I think was the caller. Sir, can you raise your hand one more time? Press *5. I can pull you up. Press *5. Okay. So let me explain to you what is going on with birthright citizenship. First of all, let's understand the history of what's going on. Under the Constitution, there is no doubt, there are precedents from the Supreme Court, the language of the statute appears to be, or Constitution appears to be pretty clear, that anybody who's born in the US is a US citizen. Okay. Trump wants to take that away and say that unless you are a permanent resident or a U.S. citizen, if you have a child here, it doesn't matter. They're not a U.S. citizen. All right. Now what happened was, there was a separate problem. The problem was this, that one judge in one state could issue an injunction that was binding on the government in all 50 states. So recently, Supreme Court took that up and they said, look, one judge sitting in one state, a federal judge, cannot bind the entire government in all 50 states. You can bind the government in that state because that's your area, okay? But you can't bind them in all 50 states. So in other words, nationwide injunctions are no longer allowed. But does that really matter? No. Why? Because in the same judgment, several judges said, and that doesn't mean you can't do class actions. What is a class action? Nationwide injunction says, this policy is illegal. Don't you dare enforce it in any of the states. Class action says the exact same thing, but a little bit differently. What does it say? Class actions are filed when the number of people covered by a particular problem is so large that they can't be clubbed together. Or we don't even know how many are there. Okay, that's called numerosity, too many people. Okay, so I've got 10,000 people or 20,000 people, or I don't even know how many people, and some are still having babies, who are covered by a class. And how do I define a class? I define the class, let's say the executive order was issued on February 2nd. All the children born in the United States from February 2nd onwards to the final decision of the case are a class. What does that do? If that class is certified, which means the court sitting in New Hampshire says, yes, we agree, this is a class. Now, we are not impacting the federal government in all 50 states. We are impacting the class members in all 50 states. We are saying, Mr. Government, you can't apply this nonsense to members of this class anywhere in the country. The end result is the same, but how we got there is different. In one, which was the one that was banned by the Supreme Court, the law could be a problem and just two people from that state could walk in and say, ban this law in all 50 states. And they wouldn't ask it like that, but that's what would end up happening. But in the second situation, which is what is happening now, there's a class action and the class is certified. Now everybody is covered by that class. The government cannot hurt you because you're a member of that class. Do you have to do anything special? Do you have to actually go and enroll somewhere? No, you do not. Once the class is certified, even though 5 people represent the class who are actually named in the lawsuit, everyone who is a member of that class automatically is covered by that decision. I hope that makes sense. Sir, Texas?
Yes, absolutely.
Okay, so it's going to happen. This class is going to get certified and you'll get protection. That is my prediction. People have asked me, should I go to Maryland and should I go to another state to have delivery? I don't want to put my foot in my mouth because I don't know what tomorrow brings. But if it were my baby, I would sit tight and say, you know what, I'll deal with it. Let's see what happens.
All right. Thank you so much, sir.
You are very welcome. Anybody? All good? We did very well. Just 6 minutes over my time. Thank you all. I'll see you next week on Zoom. Take care, everyone. Bye-bye.